Hi everyone. Today's video is all about reasonable care. What is reasonable care and why is it important? This is just a quick video to give you the highlights. So if you want more detail and information, you can check out our separate document all about reasonable care. As you'll know from the other content and material we've made available to you, from the 6th of April 2021 onwards, clients will be legally required to determine the tax status of any PSC contractors they use. Now, if the terminology I'm using isn't familiar to you, check out some of our other materials, which will explain the rules and the terminology we're using in a bit more detail, and then come back. Under the new rules, clients need to decide whether PSC contractors are genuinely self-employed for tax purposes, that is outside IR35, or employed for tax purposes, which is inside IR35. Clients are required to exercise reasonable care when they make these IR35 status determinations. And HMRC explains reasonable care as acting in a way that would be expected of a prudent and reasonable person in the client's position. Essentially, that means you, the client, should do everything that is reasonably possible and conceivable to make IR35 determinations that correctly evaluate whether an assignment is inside or outside IR35. However, clients aren't required to make sure that every single status determination they give is correct. By correct, I mean whether the determination reaches the correct conclusion as to whether a PSC is inside or outside IR35 for a particular assignment. If the client has reached a determination using reasonable care, but the outcome of an individual assessment is incorrect, clients won't be liable for that incorrect outcome or any of the liabilities, the tax and national insurance contributions associated with it. Those liabilities move on to the fee payer. That is the company who pays the PSC. If there's a recruitment agency in the contractual chain, then the agency is the fee payer. If the client engages the PSC directly, then the client is the fee payer. If a client fails to take reasonable care or doesn't comply with any of its other obligations around timing of issuing assessments and who to give determinations and who to pass them to, then it's the client who is responsible for all of the liabilities under the off-payroll rules. It's important to recognise that reasonable care is a variable standard. Every client's threshold for whether they've discharged their duty of reasonable care will be different, because every client is different in terms of their abilities and experiences and circumstances. So, for example, larger companies with lots of PSCs, they will be expected to take more care and demonstrate that they've implemented and followed a more thorough and rigorous process than perhaps a much smaller business who has very few PSCs and limited internal resources. So, if you are a client, how do you make sure that you assess your contractors with reasonable care? Well, first you should ensure that all of your staff, especially those involved in making determinations, are properly informed and educated both about the new rules and the principles that underpin IR35 status. If you have the right specialists in-house, you could manage the rules yourself, using a combination of legal, tax, finance and operations staff to ensure all the relevant information is accounted for and any determinations reach the correct conclusion. You could choose to use the government's own Check Employment Status for Tax or CEST tool, though it should be noted that the tool really does have some significant failings and it only supports HMRC's view of IR35 status, as opposed to the view of a tax tribunal, and it is the tax tribunal that is the ultimate authority on deciding employment status for tax purposes. Alternatively, you could utilise external support, engaging IR35 experts to help you conduct accurate and complete assessments. You will need to conduct thorough due diligence on those advisors and keep records of that due diligence so that you can show HMRC that the advisor is a genuine expert. And we've given you some kind of top tips for the types of checks that you could be undertaking in our separate document about reasonable care. So what are some examples of reasonable care? Well, in terms of behaviours that would indicate that a client has taken reasonable care, it would be things like showing and being able to prove that you as a business, you understand the principles of tax status and the factors that determine whether somebody is employed or self-employed for tax purposes, whether that's through your own research or external advice or HMRC guidance or some combination of the three. Ensuring the right people within your business are involved in the determination process. So people who have a good understanding of the work being done by your PSC contractors and the actual day-to-day working arrangements. Conducting assessments with as much accuracy as possible, of course, and keeping clear records of the outcome, the reasoning, and who the determination was given to and when. Checking determinations over time to ensure they remain valid. Where there are any changes to a PSC's assignment that could impact IR35 status, you'll need to conduct a new status assessment and issue it in the same way. Regularly reviewing your policies and processes within your business as they relate to the off-payroll rules and amending and improving them as necessary over time. On the other hand, some examples of behaviours which would not constitute reasonable care include things like determining that every PSC is inside IR35 without considering the specific facts of individual cases. And this is what we call a blanket determination. And HMRC has confirmed this will not be considered reasonable care. And HMRC will make clients who take this approach liable for all of the taxes and national insurance payable under that assignment, even if they've been paid elsewhere by another party in the chain. Now, while role-based assessments are perfectly legitimate if multiple contractors are undertaking the same role, have the same terms and conditions, and are treated in the same way, you do need to make sure that you give proper consideration to any differences in their tasks or contracts or working arrangements. Otherwise, you won't discharge your duty of reasonable care. If you use inaccurate information to conduct a status determination, or you fail to take into account all relevant evidence, that would also be evidence that you haven't taken reasonable care. And another area is not providing enough support or training to enable the individuals who are going to be responsible in your business for making determinations to properly consider the off-payroll working rules and make those accurate determinations. Well, that's reasonable care in a nutshell. I really hope you found the information helpful.